Thank you, sir.
Thank you, Mr. Chairman. I want to thank this committee for the opportunity for all of us to come here. I wanted to go ahead and say, while I'm here to speak with all of you on behalf of the criminal justice community, I'm also here to talk more globally on behalf of the state. And I'm not going to answer, or I don't presume to have an answer or a prescription for every problem, because there's a lot of people up here who intersect with the criminal justice system differently. And everyone has a difference of a point of view or a difference of opinion. So I'm not going to address every single possible thing that happens in the criminal justice system. I also want to thank this committee because what you're undertaking is not as easy as it sounds. And when people talk about judicial reform, I want to make it very clear that today I'm here to talk about JMSC reform. Okay, JMSC reform is a subset of judicial reform, and there's a lot of components. There's magistrate reform. There's, people are talking about diversity on the bench. There's all kinds of reforms that need to be addressed, and we welcome that conversation, and we look forward to future conversations. But my remarks today are going to be narrowly tailored to how judges are elected and selected. I want to start by saying, when I began this year, I went and met with the Speaker of the House, and this was ahead of the Murdaugh trial, so I was kind of out of pocket for a few months after that. But he and I had a very thoughtful conversation, and a number of you and I had very thoughtful conversations earlier in the year, and a commitment was made that we would have something like this, an opportunity for us to have this conversation. And I want to thank the Speaker for obviously setting up this ad hoc committee, and I want to thank you, Chairman Pope, for chairing it and all the members of it, because every one of you has a stake in this, and we appreciate and welcome the opportunity to have this conversation with all of you. And I want to thank the leadership of the General Assembly in both the House and the Senate. I know that there are people who are more skeptical or maybe more resistant or maybe just have more questions. Whatever corner of the spectrum you come from as it relates to JMSC reform, we appreciate the opportunity to have a productive, constructively critical conversation on how we can move forward. Now, with that being said, I'm not here today to attack anybody that's a stakeholder, whether they're a judge, a legislator, a prosecutor, a law enforcement, or anyone. We all inherited this system that we have here today. This system predates nearly every one of every one of us serving in the public. The system that we have today has produced many wonderful judges. And I'm not going to castigate or diminish their contributions, and I do think the system has worked on a number of occasions. But it's kind of like the analogy I've used. If I told you that the system for flying planes works 85% of the time, or 80% of the time, would we not want to get to a higher percentage of safely landing planes? And so I'm not here today, and I heard last week's testimony, someone made a comment about throwing the baby out with the bathwater. I don't think we need to do that. I don't think we need to burn the proverbial village in order to save it. The JMSC is a creature of the state constitution. It is under Article 5, Section 27. It is baked in there, and the Constitution requires that there must be a JMSC. It requires that you, the legislature, must create a JMSC, and that you, the legislature, shall elect nominations made by the JMSC to the full body. That is all baked in. That stuff can't be changed, and I don't hear anyone advocating for changing the constitutional prescriptions for selecting judges. What we are here to talk about today is that there are ways statutorily that the executive branch of government can be made an equal partner in the selection of judges. That's what I'm here to advocate for. My colleagues in law enforcement and in the solicitor ranks, they may have different perspectives and different ways of approaching this, but my approach today is going to be to tell you what you already know, that there are three branches of government, okay? We are in a branch of government, and I think Justice Kittredge last week in his testimony, I couldn't be here, I was on the road, but I did listen to it, and I agree with nearly everything he said, if not everything that he said. But I think in one of his responses to a question, he quoted Federalist Papers 51, where Madison talked about in the three branches of government, at least at the federal model, which we hope to emulate here in the state model, that you have three silos of power, three branches that are supposed to check the ambitions of each other. As long as human beings are in government, government is going to be flawed. And what we're asking here today, what I'm asking of all of you, is to make the executive branch an equal partner in the selection of judges. Now, I can tell you why. I'm going to give you a couple of examples in a minute. I'll tell you why, but let me work into that. First, as I travel the state and I have conversations with people, whether it's members of the chamber, your Rotary clubs, your political groups, your church groups, whoever will listen, legal groups, I talk to folks, and while people don't talk about judicial reform as a bread and butter issue at the table. It is something that they are concerned about, and when they have conversations, they do agree that there is a perception issue. And so, as we address this, as we ask all of you to address it, I want you to focus on our interest, the interest of the executive branch of government, not our positions. Now, I want to explain the difference between an interest and a position. When we met Chairman Pope, I used this analogy when we were in Charleston months ago. The difference between an interest and a position is exemplified by a scenario where two women enter a grocery store and they both reach for the last orange. And they fight over the orange and they ultimately negotiate a compromise where they will cut the orange in half and they will each pay half the price of the orange and walk out with half an orange. The next day they bump into each other and have a conversation only to realize that one woman wanted 100% of the pulp and the other woman wanted 100% of the rind. The woman that wanted the pulp was making a glass of orange juice. The woman that wanted the rind was making marmalade. And had they had a conversation, a constructive, critical conversation about what their interests were, not their position was they wanted an orange. Their interest was one wanted rind, one wanted pulp. They could have gotten both 100% of what they wanted at half the cost. So today I'm here to talk about our interests. Yes, there are positions. What are the qualifications of judges? Who are the qualifications of the members of the JMSC? How long should the members of the JMSC serve? How long or how many positions should be appointed by the governor? Or should they all be? Or should some or portion of them be? Those are all positions that reasonable people can have conversations about and have different points of view and maybe even disagree and we can compromise on. But the interest is this. There's three branches of government. In the process of electing judges, the executive branch has 0% involvement in it. And what we want, those of us in the executive branch charged with enforcing the rule of law, the laws that you all pass, is to have an equal check. And so, like in the orange analogy, I'm here to advocate for our interest. Now, the way the current system works, and it's not a bad system, but it could be a much, much better system. There are 10 members of the JMSC. All 10 are elected by the leadership, 3 members of the legislative branch of government. 6 of them are actually sitting members of the legislature, 4 not sitting. What we want is, and when people talk about judges and how they rule, the one thing I'm hearing from people on the ground is this, is that we feel like if we don't like the quality of the judiciary or the judges or the rulings by judges in particular cases, we can go to our House member and complain. We can go to our senator and complain. But there's 168 other members of the General Assembly. And so really our legislator can say, look, I voted for or against the judge, but that's where their involvement stops. The reason the executive branch needs to have a significant weighted representation in the selection of judges is because everyone votes for the governor, the whole state. And so we have a system where power and control over the selection of judges is consolidated in one branch of government, while accountability for those decisions has been basically expanded. Power's been consolidated, and accountability, rather, has been dispersed. And so we kind of want to couple power and accountability, or we want to put those two together, and which is why we think making the JMSC selection process and adding the governor as an equal partner in this process to represent the executive branch of government. Now, there's some people up here who are going to come and talk to you in a minute, and they can talk to you about their personal experiences. I did poll my office, and I did poll prosecutors around the state to give examples of where they perceived, whether it was real, it was at least perceived, improper influence by people practicing law who also serve in the General Assembly. Now, I'll be the first to say this. The vast majorities of the stories I've gotten are not representative of the vast majority of people who are lawyers who serve in the General Assembly. And frankly, in my personal experience, the vast majority of lawyers who serve in the General Assembly in both parties have been very easy to work with and very easy to talk to. But it only takes a couple to ruin it for the rest. And I could sit up here today and I could read to all of you all of these anecdotal examples, but I've narrowed it down to just a couple, very, very few. And this will kind of exemplify. I have sanitized the stories to eliminate, so I hope you can't identify who the judge or who the person on the other side was. I don't want to do that, but I want some of you have asked for examples, you've asked for data, you've asked for statistics and information, so this is me doing what some of you have asked me to do. So recently, I was talking, when I say recently, this past year, I was talking to a CEO of a fairly large company that does business here in South Carolina. The CEO, and I don't want to identify the company, but the CEO is not from here, and this company has a footprint in multiple states. The CEO was telling me the story of how what occurred was this company, in an effort to build relationships with local communities, decided to, because of the type of work that they did, they offered safety courses. This company is a heavily industrial company, and so they train their employees in the type of work that their employees do. They decided to offer training at cost to local municipalities within the footprint of this company's service, right, what they do in the state of South Carolina. And so they offered at no additional charge to municipalities free safety trainings to their employees, their municipal employees who engage in the same type of work that the employees of this company engaged in. And they had done this for 20 years. Well, one of those employees for a municipality took that course, then 15 years later suffered a horrific accident on the job. Not working for this company, not on the company's property, not doing anything on behalf of the company, just had taken a course 15 years earlier. Anyway, this person who had been harmed hired an attorney, and they sued, obviously, the property owners. They sued the people on the site. They sued the company, or they sued the municipality. They sued everyone, and then they sued the company that offered the free training 15 plus years earlier. So right ahead of the trial, the CEO and people flew in from out of state. They had local counsel. They were at the courthouse, and I'm giving you the very truncated version of the facts, but this is what the CEO told me. He says, I'm sitting there, and across the way is the attorney representing the harmed individual, and a lawyer who also serves in the legislature, and I'm not saying which side, but is in the General Assembly, walks in, and this is actually works with, is actually a law partner with this individual. And at some point, the CEO overhears a conversation. The judge is here. You should probably go out and talk to him. And then the legislator leaves and then comes back a short time later. I don't know if it was an hour. I don't know if it's 2 hours. I don't know what. It was a short time later, and they proceed to have pretrial hearings. And what the people at the company and the CEO tell me is that we lost every single motion. Things that came in we thought weren't relevant were allowed in. Things that we thought were relevant and were defensive of our case were kept out. And we ultimately lost the case because of all of those evidentiary hearings, and we were on the hook for millions and millions of dollars. And the CEO said, here are some consequences of that. We no longer offer those at no extra cost. I mean, they made no money on the training. We ceased and desisted in doing all of that. Other municipalities were upset that we quit doing that safety training for their employees, which they now have to pay for. The other thing is that the CEO left me with this. He says, Alan, we love doing business in South Carolina. It's a great state. It's got good people. It's got a good workforce. But the impression we were left with, and we don't know what happened when that legislator left the courthouse and went and met the judge outside. We don't know what was said. It could have been completely innocent. But the impression was that there was influence on that judge. Not that it definitely happened. That was the impression. So when people ask me around the country, because CEOs talk with one another, they talk about how, oh, you guys are in South Carolina, how are you doing? We're thinking about opening a plant there. We're thinking about doing business there. The CEO says, I say a lot of wonderful things about the state, but I always tell them that story. Because, and I think the term used by the CEO from their perspective, this is not my term, I'm quoting, judicial hellhole is what they qualified it as. Now, I don't think we're a judicial hellhole. I think we have some amazing judges. In fact, the vast majority of judges are amazing. But the perception left was that if you're a business and you see a legislator on the other side, then you're going to get shaken down. That is how they left. I don't believe that is true, but that is how they feel. I don't want people to think that way about South Carolina when they're thinking about doing business here. I want all of your districts to get plants and businesses and companies moving here, expanding opportunity. And so that is one story I tell you that illustrates, and it's outside the criminal justice arena, but it's an important story because it sends a message. By the way, I'm not here today to tell you that changing JMSC, who's on the JMSC, is going to fix all these problems. but it does send a powerful message when the legislature itself owns the perception and says, you know what, you're right. We need to bring the executive branch to the table. Now, here's another story, and I'll make this brief. I was speaking to a group a couple of months ago, and I don't know all the facts on the other side. I'm telling you them as they were told to me. A woman came to me and she said, after we talked about JMSC reform, she says, Mr. Wilson, I have a story I want to share with you. She said, I serve on the Citizens Advisory Council, which is one of the two advisory councils that makes recommendations to the JMSC. Now, I'm going to sanitize this story almost to the point to where it doesn't have the same impact if you knew the full facts, but you'll still get the point. There was a person running for judge who had been an attorney for many years, but nearly all of their time had been in government more as an administrator. They had never practiced law. This individual was running for judge, and their packet, their application came before the Citizens Advisory Group, and the woman that I was talking to said that we reviewed it, and this was a very good person. They seemed very intelligent, but they had zero experience in doing the kind of thing that they were going to be judging over. They had never practiced in a courtroom. They had never had a case in a courtroom. They had never even practiced law. It was more administration and government. So we wrote on it, we wrote a letter saying, you have many wonderful attributes. However, we don't think you're qualified at this time. We recommend you go practice law for a couple of years and then come back, and then we'd be happy to recommend to the Judicial Selection Commission that you should be considered for qualifications as a judge. The woman said they later learned that the JMSC found this individual, and I don't know how many people were applying, but this person was found most qualified and ultimately was elected to the position that they sought. And all the members of this advisory committee were like, wow, I mean, no experience, and they were found most qualified. And that was the perception that they were left with. I'm not going to give you any of the other examples of day-to-day engagement that many of my colleagues will probably talk about because, frankly, I want to give them more time. I don't want to take their time from them. But before I sit down, or before I at least answer some of your questions, is that going back to the interests that we have as the executive branch of government, what would I like to see happen? I think the JMSC, there needs to be equal partnership. You all have created the JMSC as you're required to do under the Constitution, and you all get to have the final vote on what judges are elected to the bench. If you don't like the types of judges the JMSC is putting out, you can vote them down. You should have that ultimate power. You should have that ultimate say. That is a check. The judges should be able to look at all of us, all of these prosecutors up here. They should check our power under the Constitution. We welcome that. We want that. We want that check. What we want is not us, but somebody in the executive branch to offer a check on who gets to serve on the judiciary. We think, and I would prefer, that no current legislators, and this is not a knock on those of you who serve on the JMSC, you inherited this system and you serve honorably. But I think a good system would be one where legislators do not currently serve on the JMSC. My preference is for the governor to appoint, if not all, at least a significant majority of the JMSC members. I think the JMSC would be best served if it was removed from funding under the legislative branch and made a separate standalone commission with separate standalone staff, and then removed out from under these buildings. Let it be a standalone. Let it be in a separate brick and mortar building with separate lines of funding with staff who are accountable to the commission members. And then remove the 3-candidate cap. Obviously, I know that you don't want to have 10 elections, but you guys can set the rules. You can pass laws. I'm not telling you what to do, but I think sometimes there's a perception that there's a preferred candidate and 2 throwaway candidates. I'm not saying that happens. That's what I'm saying people tell me they feel happens. If someone's qualified, let them run. If there's 10 people running and you guys want to say the first top 3 vote getters go to the second ballot, and then you choose from that like you do now, that's fine. Make up your rules, but remove the 3-person cap and give everybody a chance to be heard. Give everyone a chance to be vetted and questioned by the legislative branch. And then obviously, I think term limits, if I understand, are coterminous with the appointer. Obviously, if y'all change the makeup of the JMSC, we would like to see term limits. I don't want to see any one person who's not directly publicly elected to be able to sit in one place for 5, 10 years at a time. So I think it would be nice if there was at least a term limit so that there was at least more turnover, or at least an opportunity for all of you and for the executive branch to question the commission members if we don't like the quality of judges or judicial candidates that they're putting out. So removing the 3-person cap. So those 5 things that I just mentioned are things that we're asking you to prayerfully consider as you factor those in. Again, the executive branch of government, these are your police chiefs, your sheriffs, your SLED chief, your Department of Public Safety, your solicitor, your line prosecutor, even your agency directors who aren't in law enforcement. Our job is to enforce the law. We appear in front of the court every day, and the court judges us every day, and they check our power every day, and we welcome that. We want that. We want representation, and we feel like when I'm talking to CEOs around the country, and I can tell them when they're talking about, and they refer to South Carolina as a judicial hellhole, and they start attacking the legislature or lawyer legislators who practice law, I can say, wait a second. This group of men and women in a bipartisan fashion, they brought us to the table to address that concern. And I can sell that when I'm traveling the country, when we're out there recruiting business for the state. I can sell that. I can say my legislature came and they brought us to the table, and they brought accountability to the way that judges are selected. And if you don't like the judges and you think they're treating you inappropriately, then we can at least go to the governor. The governor can talk to the commission members and the general public, the victims. All of us feel like we have representation in the selection of judges. So I want to thank you for letting me talk. I did not read a single word of my testimony because I just wanted this to be organic and authentic. But I thank you for listening to what I had to say, and I know that my colleagues who will follow me will give you a lot of food for thought, but I'm happy to entertain any questions that or comments you all may have.
Thank you, General. I appreciate it. Also, I was remiss, and I appreciate you pointing out that I believe it was you and your office, the bar, the court, Chairman Newton, myself, and the Speaker's office have been meeting since January on this issue, and you pointed that out, and I appreciate it. It wasn't like something we decided to do last week, so I certainly appreciate that. Mr. Caskey has a question, I believe.
Thank you, Mr. Speaker. And Mr. Attorney General, I certainly appreciate you being here. You were somebody that I have known most of my life. Fun fact for those, Alan at one point was my babysitter. So,
and he was an angel. An angel.
Still am.
That explains a lot.
I say that to say that I'm firmly in the camp of people who have more questions.
Okay.
Unlike perhaps how some in our mercenary media want to portray it, I'm not here to defend the status quo. I am here, though, to insist that we apply rigorous analysis to any proposal that comes forward, and that we do that in a thoughtful way to uncover, as best we can, what realities might then come from the adoption of any of these particular proposals. So my questions are in the spirit of trying to understand how the various proposals and the various logic that has been applied here or been suggested and been applied will help us. And to that end, I guess I will start at the top. I know you framed your remarks as being limited to JMSC, but you touched some other areas with respect to judicial selection models. Do you support judicial elections being popularly done?
No.
Okay. So you're not here to call for us to overhaul then our probate system?
I am here narrowly, I haven't even thought about that, Representative Caskey. I've solely thought about the constitutional scheme that we have to address here today on the selection of judges that have to get approved, qualified, and nominated out of the JMSC. That is, I'm limiting my comments and my recommendations to that.
And I don't want to, I don't intend to have a whole bunch of gotcha questions, but I got questions.
Okay.
And so if you don't support popular elections, then I got to wonder why you would support the election of probate judges like we do now. If you don't want to talk about that, I understand. But I'm going through this again rigorously to figure out what is the problem that we're going to ultimately be able to solve by changing the composition of the JMSC. Because as I understood you, you also said something about, and I don't want to put words in your mouth, something about moving toward the federal model. Is that an accurate summation of what you said your goal would be?
So when I met in Charleston, I was saying I want to go to a model where the executive and legislative branches have parity of power, and the federal model has that. But we are very different than the federal model. we don't have, U.S. senators don't practice law in front of the judges. The judges at the federal system are lifetime appointments. I'm not for that either. By the way, I am not for or against probate judges being elected or other judges being elected popularly. I don't have a position because I haven't thought about it. I wanted to put that on the record. So when I say the federal model, it's the interest, not the position. The interest is I want a system where the executive branch of government is an equal partner in the selection of who gets to be in the judicial branch of government. Right now, we're not at the same table with the legislature. We're not even at the kids' table. We're outside with our face pressed to the glass, and we want to be a partner. We want to be an equal partner in how judges that go through the JMSC are selected.
So you're not advocating a model wherein the governor makes an appointment or appoints a judge subject to confirmation. That's not what you're advocating
No,
for.
that's not what I'm advocating. Representative Caskey, and I'll be clear. I'm not advocating for changing the Constitution. The JMSC under Article 5, Section 21 says that there must be a JMSC, that you all must establish it. You have done that, and that you all elect judges nominated by the JMSC, and you are currently doing what the Constitution requires. The Constitution is silent to a lot of things, the makeup of the JMSC, the qualifications, things like that. We are asking for you to bring the executive branch of government to the table statutorily under the rubric of the constitutional scheme that's currently in place.
And so you would be satisfied with some modification of the JMSC system. Is that fair?
And I've been saying we a lot, and there's a lot of people here who can speak for themselves. I'll say I, but I presume that they will agree with most of what I'm saying, yes. A reforming of the current system. I said earlier we don't need to burn the JMSC down to save it. The JMSC can exist, but I think that we can reform it statutorily to give the executive branch, make us equal partners with you in the selection of judges that we also have to appear in front of.
I appreciate the clarification, because my concern is that we're going to spend time and effort to make some changes, and then we'll end up in a world where we're back here in some period of time, and folks like you, perhaps you yourself, will say, that's not enough. We should have just done the constitutional change. If that will fix the lack of public confidence that you suggest exists, then I want to make sure that we do that now. Let's not kick the can down the road. So I can take you at your word that some modification of the JMSC process to give the executive branch a voice would satisfy your concerns.
Yeah, Representative Caskey, I think that's an accurate statement that you said. I just want to say that I think JMSC selection of judges is just one component of judicial reform. So if we come back and talk about other aspects of judicial reform, it could be magistrate reform. It might even be the issue with, I don't appear in front of probate judges, that's not my lane, but there may be other people coming up here saying there's other components to judicial reform we need to address. I don't want anyone to say, well, we came and we gave you a couple things, we gave you a couple of slots in the JMSC, we're good forever. I don't ever want that to be thrown in my face. I don't think they want it thrown in their face. So, and again, my colleagues in the law enforcement community and the victims community can speak for themselves, but I would say that it goes a long way. It would go a long way to bring us to the table in this process for selecting judges, and I think it would make a lot of people happy. Now, does it mean that we will be 100% happy with the status quo in other areas? No. I think we're always looking for ways to improve our system of government, but this goes a long way, Representative.
Well, and I appreciate that, because one of the charges that the Speaker has levied for this committee is to consider the magistrate system, for example. And the fact that our magistrates are now effectively appointed by a senator. We go through a process where we say it's a nomination and then an appointment and then a confirmation, but in a practical sense, those people who are not even necessarily lawyers, who are handling the overwhelming majority of our bonds, which seem to be one of the major issues in this state, is not being addressed by anything that you're talking about here with JMSC reform, right?
That's by design. Representative Caskey, I absolutely think we need magistrate reform. I think it's a very broad conversation, but I think magistrate reform deserves its own ad hoc committee. It deserves its own day in the sun. I think this thing is so broad, the bigger and more comprehensive you get, the more of an ombudsman type package you pass. I think the more problematic it comes, A, to get passed, B, people start sticking all kinds of things in there, and it starts getting watered down, and you get poison pills in it, which is why my approach is, let's start with, if we're going to eat the steak, let's eat it one bite at a time. And right now, today, the bite that I want to take is involving the selection of Family Court Circuit, Court of Appeals, and Supreme Court justices, which are the judges that go through JMSC certification or qualification. That's what I'm focused on today.
Yes, sir, and for reasons that I think are self-evident, I'm focused on one of the three things that the speaker charged us on this committee to do, which was pay special attention to the magistrate system. I view that, based on the reports I read, based on the conversations I have with law enforcement, that is a significant obstacle in this state to ensuring that we are in a position with an effective criminal justice system. And so I'm not as eager to just brush over that and say, well, that should be a second order concern. And so, and I'm not putting it to you today to bring forward a proposal, because again, I think we will have more conversations about it, but I think we ought to pay a lot of attention to our magistrate system, because we've gotten bogged down on several of these JMSC aspects that are absolutely concerning. And that was the number one thing that the speaker asked us to look at, and I'm happy to do that. And so I'll leave that to the side, but I certainly invite your participation in that conversation about how to fix our magistrate system, because I don't think we should just rush past that. I do want to go back, though, to a comment you made about you're not involved you're not involved as the executive branch in the JMSC system, sitting at you're not even at the little kids table. And that may be true insofar as you defined the JMSC narrowly as the 10 members who sit in the Gresset building and make votes. But our JMSC system is bigger than that. And I think sometimes it's not adequately explained what the JMSC process looks like to include the Citizens Committee and the Bar's Judicial Qualifications Committee. You do have representation on those bodies, right?
I don't know who all the members are of those specific bodies, but those are not hardwired into statute.
The chair of the Judicial Qualification Committee of the Bar works for you in your office.
And well, what I'm saying, Mr. Caskey, is those are advisory. I mean, again, in my initial remarks, the advisory committee, not the Bar one, but the advisory committee. And by the way, I didn't know I had an employee serving on those committees. I don't have any input into those committees. But a minute ago, I just said that the advisory committee made a recommendation of unqualified, and the JMSC said they're most qualified. So if there are people who in their individual capacities serve on those committees but also happen to work in the executive branch of government, that's not the same as the executive branch of government being represented. That is very different. I do want to say one other thing. You mentioned earlier, and I want to let you get to your second question. I agree with everything you said about the need to address magistrate reform. 100%, Representative Caskey. It is not of secondary concern to me. It is of equal importance as to what we're talking about today. But I came here just because I'm talking about one thing doesn't mean that I don't think it's of equal importance. So I hope that this committee or this body eventually takes it up and that we do pass magistrate reform.
Before you go, Mr. Caskey, that is our intention to deal with the magistrates reform also, and I know a number of the guests are going to touch on that too.
Thank you, sir. Well, it's not only employees in your office. I think some of these gentlemen and lady behind you have folks in their offices who are participating in these citizens committees. But I take your point that maybe those folks don't count as executive participation, but you personally have had opportunity to weigh in on these candidates, right?
The ability to go and appeal to a legislatively controlled commission that selects judges and give my input is not the same as having representation on the commission. That to me, I distinguish that. I'm not saying that y'all don't let us come and talk to you about judges. I mean, of course the JMSC does, and the JMSC does a great job of that. It's just that we, as the executive branch, don't have anyone on that commission that's hardwired into bringing parity of power among the branches.
So, okay, I think you've met with judicial candidates, right? And you have, offered to support or not support candidates at times, I'm sure. Is that right?
Absolutely. I've met with a number of candidates over the years, and they've asked my advice on, the job. And of course, I meet with them.
So then help me then with the problem that I see with part of the argument that I'm hearing, which is that because a lawyer legislator or a legislator sits on the JMSC, there is therefore a conflict of interest or a potential conflict of interest, but that potential conflict of interest would not apply for a solicitor or an attorney general who is on the JMSC.
I'm not advocating to be on the JMSC, or I don't know that the solicitors are advocating to be on the JMSC.
Would you be willing to serve on the JMSC? Not your designee, not your appointee, but you personally.
I think that would be ill-advised to put me or my designee on the JMSC, Representative Caskey. I don't think we want a pro-law enforcement JMSC. We want a JMSC that gives the appearance of neutrality and balance of power across the three branches of government. So I would not advocate for an appointment to the JMSC or for me to personally sit on the JMSC, because then you have to invite in the defense bar, and then you start having to weigh all these other purposes. I just feel like it's safer to keep the personalities and the people like the Attorney General should not be on the JMSC. We'll just say that, leave it at that.
Then your designee or the governor's designee, if it's a lawyer, how do you reconcile then the conflict of interest that would arise when that person or his or her partners served on the JMSC?
When you say conflict of interest, I'm sorry, I don't understand.
So insofar as there is a conflict of interest in court, under your argument that the lawyer legislator then is inescapably attached to, right? Lawyer legislator shows up in court, and judge is affording some deference to the lawyer legislator on JMSC because of his or her status, right? That's central part of your thesis here, right?
That the person serving on the JMSC that would be appointed by the governor would somehow have a conflict
Well,
with...
back up. Let's just say, as I've understood you, and please correct me if I'm wrong.
Okay.
As I've understood your argument, the lawyer legislator who serves on JMSC, when he or she,
I'm sorry, I'm cutting you off. I want to take away the term lawyer legislator. Let's just say legislator.
okay, well, it becomes, and I appreciate that because I think there are far too many people who have decided to use that term as a pejorative, and I think it's a profound disservice to the state of South Carolina and to the bar as a community. So I appreciate that. But in this instance, I'm referring to a legislator who then will appear in court. So given that, I've understood your argument to be that that person, when appearing in court, may have some appearance of bias or benefit because of his or her status as a member of JMSC. Is that part right?
I think I understand how you're framing the issues, that you're saying that the same conflicts that could exist with a legislative appointment could still exist with a gubernatorial appointment.
I'm saying that will necessarily exist. I'm saying that if a legislator who serves on JMSC is tarnished with the appearance or potential appearance of a conflict of interest, that same appearance or actual conflict of interest would attach to an appointee who practices law. And the only other alternative is to either have a individual who does not practice law or exclusively have people who don't practice law on the JMSC, or to have legislators who are full-time legislators who never appear and can't appear.
I think that's the fallacy of the false dichotomy. You're saying that if you don't do this, then the far extreme will have to happen. I don't think that's the case here. Look, as long as there are human beings in the process, there is no system that exists for electing judges that is perfect and pure and has no politics associated with it. It does not exist. There's not going to be a situation in which you can eliminate every perception of a conflict of interest or every perception of influence. That system does not exist. I want to go back to my orange analogy. Representative Caskey, you're asking really good questions. I think you're right to ask these questions. We're talking about positions, okay? I'm talking about the interest. I want to go back up real quick because I think it's important. The executive branch of government, is there an argument that this executive branch of government shouldn't have representation on the JMSC? And I don't think you're saying that. I think you're getting into, okay, what does it look like?
Well, let me be very clear, and perhaps we'll go step by step to make sure we don't lose anybody along the way. Part of your argument is that a legislator who sits on JMSC, who practices law, and then appears in front of a judge is tainted with some potential appearance of benefit or detriment because of that status, right? Do we agree on that part?
A narrative could be said about that system.
What about a narrative?
It is a narrative.
This is the central argument that you're offering. Right. Okay. It's not, it doesn't have to be a fight.
Yeah.
All right.
Well, not fighting, I'm simply, I'm saying that it could be. It doesn't necessarily mean that it will be. There have been lots of people served on the JMSC as legislators. I've never heard their name mentioned once in anecdotal stories of improper influence.
Okay, but insofar as the public has an interest in avoiding some conflict of interest problem, I've understood that to be your argument, and if I'm wrong, please correct that.
I'm going to stipulate to everything you just said and say this. I think the difference is that everyone gets to vote for the governor. And if there is an inappropriate or perceived conflict of interest by a gubernatorial appointment exercising their authority as a member of the JMSC as an attorney appearing before the judges, people can go directly to the governor. But people can't go to a legislator who's not their legislator, who serves on the JMSC. They have no say on that person. But the governor works for everybody. What you're doing is you're giving statewide accountability to who sits on the JMSC by putting the governor's appointments on there. Right now, as I said earlier in my remarks, power is consolidated while accountability is dispersed. And we want one of the branches of government that is most accountable is the executive as it relates to the governor, because everybody gets to vote for the governor. And if the governor's appointed members of the JMSC who are acting inappropriate, then if someone goes to the judiciary chairman of the Senate or someone goes to the Speaker of the House to say that you or some other member is acting inappropriate, if that legislator that appoints you on the JMSC isn't in that person's district, there's no accountability. But if the governor hears it, well, everyone gets to vote for the governor. The point I'm saying is accountability. There should be someone that represents the entire state of South Carolina, that everyone in the state of South Carolina can vote for or against, who has a voice on the JMSC. And that is why we're asking for executive branch involvement.
I appreciate that, and I'll move on because I do want to be mindful of our time. What I'm suggesting to you, though, is if you have a JMSC mechanism, which you've said you're okay with, I do not see how you can have a lawyer who sits on that JMSC who does not carry with himself or herself the potential appearance of conflict of interest. I don't see how you can resolve that, whether it is a legislator or the appointee of any executive branch official. And the testimony we heard last week from the experts who joined us by Zoom was that there is no screening commission in America that precludes its members from serving as a lawyer. There's not one.
I'm not advocating for that.
Right. So you're simply, my argument would be, or my question is, you're substituting who the conflict goes to. And I think there is value in having people who are accountable to a constituency, albeit not the statewide constituency, in that position. Because what I hear oftentimes is this lawyer legislator gets preferential treatment. And for reasons that we could spend a whole lot more time talking about, the coverage in the media tends to be lawyer legislator gets preferential treatment. When in fact, in at least one case that came from the Supreme Court, which you argued very well, the solicitor had agreed to that. He had agreed to the resolution that was offered. The solicitor and the defense attorney, who happened to be a legislator, agreed to something that they violated law in arriving at, and yet the narrative is legislator got what he wanted, not elected solicitor got what he wanted. And that's a problem for me in trying to resolve these tensions that we're getting to here.
Representative Caskey, at the end of the day, I can't provide you a solution of people who sit on the JMSC where someone's not going to claim there's undue influence. What I can say is we can have a system where the people in the JMSC, or at least a significant portion of them, are answerable to someone who is answerable to everyone in the state, to all constituencies, to all, you can call them special interests, the victims community, the business community, the law enforcement community, whatever community you want to say. And again, when I talk to CEOs and people who want to do business in South Carolina, I do defend the lawyer legislators, but when they tell me a story about that, I want to be able to come back and say, look, I took that story, which I just told you, and I took it to the legislature, and they said, that's fair. We want to create a system where there's at least the appearance that there's parity of power among the three branches of government.
And that's a great vignette that you have shared with us. But I would say to you that we should be equally concerned that those same lawyers who were partnered with the legislator If those individuals are donating thousands of dollars to the solicitor, in that case, and then receive a favorable plea deal, we should all be equally concerned about the impropriety. So again, my place is not to say that I'm here to defend where we are now. I'm simply saying we ought to ask questions about how we get to where I think you're suggesting we go, when, this is the only issue I ever see where the black man is accused of being powerful, that the minority party in this state is powerful. It's a strange paradox that we find ourselves in, and I can't understand where the source of that is when I look at our system and I think I, as a member, have one of 170 votes. There are 54 lawyers in the legislature. Any candidate can get elected without a single lawyer vote in our General Assembly. On the JMSC, I'm one of 10 votes. Mm-hmm. No other member has a greater percentage or lesser percentage than I do on that commission. And these are the tensions that I don't hear resolution of as we go forward. So I'll stop because I know others have questions. I do want to ask you one thing because it's unlikely the speaker will recognize me again while you're here. And I suspect some of our conversation going forward will involve backlogs in the state with the criminal docket. And my question is, in your capacity as the supervising prosecutor in this state, have you identified any concerns with respect to docket management in the state? And if so, what has your office done to ameliorate those concerns?
You want me to talk about that here at this committee hearing, or you want to keep it narrowly tailored?
Have you ever, well, because I think the conversation is going to go
what I can tell you is this.
backlog.
Our office has met with Justice James on how we interface with all the 16 circuit solicitors in their offices in the backlog. We do a lot of what the solicitors do, but we do a lot of other things. We do PCRs, we do appeals, capital litigation. We have a whole separate mechanism.
Civil litigation, yeah.
We're the civil side. We're meeting with Justice James, who is our kind of representative on the court, to help us figure out docket management. I went and thank you to the General Assembly for giving the solicitors the docket management software that you gave, the funding for it, rather. We're working with them to try to create a more advanced, technologically advanced system where we can move cases faster, monitor them faster. You've given us some tools that we're implementing right now. So yes, there's an ongoing conversation with my colleagues as well as with the court on how we can make the backlog around the state of South Carolina better. Obviously, as you know, under Langford, the court runs the docket, so we have to go to the court to work to resolve these issues. We can't do it alone. We have to do it with our partners.
And I appreciate that. Let me ask you directly. Have you at any point, or your office ever stepped in the same vein that the Department of Education has ever stepped into a school board that hasn't managed the school system correctly? Have you done anything like that? I'm not going to answer that question because it goes into matters that may or may not be under review at this time. Fair enough. Okay. With that, again, my position is I want to get to the same destination you do with respect to the public's confidence in our system. I want to make it crystal clear. I am not married to the way this is. I simply want to keep asking more questions so that we know that what we do going forward will give us the result that we want. So I appreciate your indulgence. I appreciate you being here. I appreciate your service. I'm grateful you're here. So thank you, sir.
Thank you, Representative.
Mr. Robbins recognized.
Thank you, Mr. Chairman. Good morning, Attorney General, and I want to thank you also for your service. It's a very important job that you hold, and y'all do a very good job. And thank you for your thoughts and sharing with us this morning. I wrote down every one of your recommendations. I think they're valid points, and they give us something as a committee to think about and ponder. I just have two areas that I want to discuss with you based on what you said to us earlier. And the first pertains to this phrase of public perception. And I would say to you that I have a question about what you consider that to be, but I also want to commend you because I believe that your office did as good a service to this issue as anybody could have done with the trial that you conducted earlier in the year. I also want to commend you for actually appearing in the courtroom. That'll be a question probably for the elected solicitors later. but you actually participated in the trial, which I think is commendable. But tell me how having that trial on TV every day for 6 weeks or so, where a South Carolina judge was viewed by the entire country, probably some people outside the country, and a trial where justice was delivered, and by all accounts, the trial judge conducted himself honorably, how that particular case did not alleviate any concerns that the public has about any troubles with our judiciary. And I believe, if I'm not incorrect, that the lead defense counsel for the defendant is a venerable member of our state Senate. And as I watched the trial, every ruling went against that sitting senator who was representing that defendant. So I'm curious to hear what this public perception is, and try to understand where the public outside of litigants who have been defeated in court is concerned versus the campaign that you and the solicitors and the sheriffs have been waging. If you could help me there.
First off, I want to give full credit to the team that prosecuted the case, and allowing me to be there to be part of it was an honor of a lifetime. And I know that the solicitors sitting behind me, they try cases themselves every single day, and I commend them for representing their constituencies. The answer to your question was embedded in how you phrased it. First off, before I tell you what that answer was, in my opinion, Judge Newman is the gold standard for trial judges. I wish I could clone him and replicate him in every facet of the state. Not because he ruled for us, even when he didn't rule for us in other cases. He's always thoughtful and measured in how he approaches an issue, and I can always see his point of view even if I were not to agree with it.
I would wholeheartedly agree with you.
With that being said, you said the entire eyes of the country or the world were watching that unfold. The whole eyes of the country and the world aren't in every courtroom, aren't in every bond revocation hearing or every plea or every trial in Dillon County or Darlington County or Hampton County. The public doesn't take the same level of interest and focus. And so to me, sunlight is a great antiseptic to inappropriate conduct in the courtroom. I think Judge Newman, had this trial been held in a broom closet with no cameras around, I think he would have come to his same deliberations. I think he would have conducted himself appropriately either way. But for the people, for the judges and or legislators who would choose to exploit or be exploited by the system we have stood up, they're not going to have a camera in every courtroom. Yes, they have what's on the record and transcripts, but you don't have the eyes of the world watching everything you do. And there's something else, Representative, I didn't say this in my opening statements, and I think Representative Caskey mentioned, we need statistics or data, and, you can't just make policy on anecdotes. And I do agree with that. However, sometimes it is impossible to take statistics and data to make a decision. And I'll give you an anecdote to represent that. We all watch football. What about that 5-star receiver that never gets thrown to because the defensive secondary, the cornerback, covers him so well they never get a ball? There's no statistic that talks about that cornerback. Or the defensive middle linebacker or defensive tackle who gets around the offensive line, hurries the quarterback but doesn't sack him. There's no stat for that, but the quarterback makes a mistake because they were afraid. Or the other team, the other women's basketball team, has to put 2 additional players on Aaliyah Boston and pull them off somewhere else, which allows other players. There's no statistic for that. There are lots of things that happen every day in the courtroom around the state. I haven't read any of the anecdotes that I was provided, but these are things that you can't define in a statistician's book. This isn't data that you can talk about. They're anecdotal and they're observations. And again, I'm not here today to read them off or to tell you about them, but every day in courts around South Carolina, prosecutors and law enforcement officials see and perceive things that may or may not be inappropriate, but they walk away feeling like it is. And they have no voice, they have no representation on the bench. Yes, our system that we have right now, it has made many fine judges. And a vast majority of lawyer legislators that I have been involved with and my team has been involved with have conducted themselves appropriately. But at the end of the day, the question is, should the executive branch of government have an equal role in the selection of judges that they're in charge of enforcing the laws in front of? And the answer to that question from our point of view is yes. So I hope I addressed your question, but I wanted to add that last little point. It is very hard to give you statistics and data when everything is anecdotal.
I think you did, and I thank you for that. I also want to talk with you about your couple of references to judicial hellhole. And I'm in my 36th year of practicing now, and the only time I've ever heard that phrase was in reference to the early days of my practice when the venue rules allowed any plaintiff to bring a case anywhere they wanted to against a big corporation that was from out of state. And it was common practice amongst the plaintiffs' bar to sue people in Hampton County because that was a great place to get verdicts. And that's what they did. And if my memory is correct, the legislature changed those venue rules some 15, 20 years ago so that that could no longer happen. But I've never heard that phrase outside of that one particular county in that one particular era that has now been fixed. And I would say that we dispense justice fairly across the state for all who appear in those courts. Would you agree with that?
Absolutely. And again, the phrase I've heard hellhole used, judicial hellhole rather, used in reference to that area of the state as well, obviously having tried that high profile case down there. But this was the term that was used by a CEO who left South Carolina with a perception, real or perceived, right or wrong. It was his words and his perceptions that I'm bringing to you today. And we're not going to be able, changing who serves on the JMSC isn't going to make every loser in a case who loses a judgment or doesn't have the outcome they want. It's not going to make them happy. But I can at least go to them and say, look, the General Assembly, they gave us seats at the table to vet the judges that you and us are appearing in front of. They didn't have to do that, and they did. And I want that story so bad so that I can go, I've given you guys credit. Y'all have created a good system, but it is far, far, far from where it could be, and that's why we're here today.
Thank you, sir. Thank you, Mr. Chairman.
Ms. Cobb, Hunter is recognized.
Thank you so much, Mr. Chairman. General, thank you for your time and,
Yes, ma'am.
and for being here. You've been questioned by two lawyers, so you know this is just a social worker trying to get clarity on all of this. So, General, I want to make sure I understand the tenor of your testimony. What you're suggesting is, and my question to you is whether or not the recommendations you've made to this committee, would those, in your view, halfway cure the problem?
What, I'm sorry, ma'am. What?
Do you think two things. One, we're focusing just on, this question is based on your point about focusing just on JMSC.
Yes, ma'am.
And my question is whether or not the 4 or 5 recommendations you made, is it your view that if we did those recommendations, removing the cap, allowing some executive authority, input, that would go a long way in correcting the problems that are out there?
It goes a long way, Representative. It goes a long way in this way. It allows us to say that the General Assembly recognized a perception issue. And of course, both myself and everyone sitting behind me could give you anecdotes and stories of our personal experiences that would support our reasoning. But it goes a long way to saying a narrative that South Carolina wants all 3 branches of government sitting at the table, especially in the election of judges. And I think it goes a long way to solving the problem as it relates to the narrative and the perception.
The example you gave, and would you agree that perception is reality, and whether we think the term judicial hellhole is accurate or not, the fact that there are people out there who believe that we have judicial hellholes, plural, do you think that one of the questions, your point was from a CEO. Based on the work that I do, did you know that there are a lot of people in the victim advocacy, victim services community who would agree with that CEO's perception that we literally are in a judicial hellhole in some respects?
Yes, ma'am. And I have a lot of anecdotes from victims, too. And I kept in order to give more time to my colleagues and others who are representing the victims community, I would let them speak for the victims. But yes, victims do share that sentiment. And I have talked to victims and I've talked to prosecutors who've said victims are very frustrated.
And I was interested in your comment about relocating JMSC off the grounds, away from the State House. And in your mind, that would serve some kind of, and I'm curious as what you think relocating the committee will do, especially as we look at considering relocating state offices later today.
Yes, ma'am. I think if you take the JMSC and you allow it to remain where it is, there's a perception that no matter who serves on the commission, and I'm not saying this is what will happen, I'm just saying it's a perception, and it's what people have told me why we probably need to move it, is that the legislative staff staffs the JMSC. So if you want to have a standalone commission where the executive branch and the legislative branch comes together, it needs to be a neutral site where the staff reports to the commission and not to the legislature. But to the commission members, rather.
The other, real quickly, because I want to allow others as well to ask questions, I want to go back to the example you gave about again, the CEO who was, this was civil litigation, but there was a conversation, so-and-so is here, go outside, they went outside, blah, blah, blah. But my question really goes to this Citizens Committee, because there seems to be a lot of stock placed in that committee by some. And I'm listening to your example of the case where the Citizens Committee recommended that the person go get a bit more experience, that they didn't think they were qualified, and then lo and behold, the JMSC let this person out. So what are we to take from that as far as what value or how much weight does the Citizens Advisory Committee really play in this arena?
Representative, what I took from that is that this individual who served on the Citizens Committee didn't feel like the Citizens Committee really mattered in the process. It's just something that we put there to check a box to make people feel like they're part of the process. What this individual told me was, this person, in their mind's eye, based on and I didn't see what other applicants were running at the time. I have nothing to compare it to. I only know the side of the story I was told. I'm being transparent. But what this person told me is that a person that had never practiced in a courtroom is now presiding over courtrooms. And we put that in writing to the JMSC, and that person was found most qualified. I don't know if they were the only person applying or if the other person was worse. I don't know. Or other people, but this person on the Citizens Advisory Committee said it really feels like it's just a check the box stop, that it doesn't really matter what we say, and that this person that was elected to the court was elected not because of what was on the resume, but either who they knew or who they were. And I don't know if that's the case, but that's how this woman felt.
Well, and I appreciate your focus on JMSC. At our first meeting, there were conversations about judges and not having any real documented cases. And from my perspective, and the people who have talked to me, the issue in their mind is not the judge, and I would agree with the assessment of Judge Newman and how he conducted that trial. But the reality from the people I talked to and the people who have reached out to me is that the issue is not so much with the judges as much as with the influence that people believe legislators have on the judges. And so what I'm curious about is how you respond to those who say it is truly a conflict of interest for the General Assembly to appropriate funds for the judiciary, to then select members of the judiciary, and then to have the option, if they want to fire members of the judiciary. How do you respond to those sentiments?
Well, my response to those sentiments is the best way to address it is to divide power and make sure that there's a transparency and accountability in that division of power. And right now, I think there could be more transparency and there could be more accountability in the system. I just think we could do a better job.
And let me just end on the point of accountability. Did you know that well, let me speak for myself. I'm getting a real sinking feeling here that we may be about to experience a similar fate that the U.S. Supreme Court has as far as releasing ethics for justices of the U.S. Supreme Court in a bow to public pressure. Do you have a sense that this will result in, and with all due respect to the speaker and my colleagues up here, do you see anything substantive coming out of this work? And not what you hope. Do you see anything substantive coming out of this?
Absolutely. The fact that we're having
Like they
this
say on Family Feud, good answer.
yeah,
Thank you.
absolutely. I'll leave it then.
Yeah, leave it there, Jim.
Yes, ma'am.
Mr. Thigpen is recognized.
Thank you, Mr. Speaker. Thank you, General. Thank you, solicitors, victims advocates, all those who are here and represent your position or your interests as stakeholders in this process. If you are not familiar with me and my approach to things, I try to be measured, try to be objective. I seek to be really more analytical. I tend to lead more towards empirical than anecdotal evidence or subject matter. I think that as we approach this, I would prefer, this is me, a pragmatic approach that really narrows down on what we are truly trying to address. So I have a great appreciation that you narrowly focused in on JMSC. I think that's, again, inch by inch, bite by bite, that's how we get to something. You know, I much like Representative Caskey, believe that good leaders ask great questions. And there's never a question that's stupid. There's never a question that shouldn't be afforded time and opportunity to be answered. So I have a few questions. You answered one of them. I know you made the distinction in your interest versus perception, and you said that legislators do not serve on JMSC. So I want to get clarity on that before I move forward. You are of the opinion, you're making the advice and suggestion that no legislator, whether lawyer or not, have any position on JMSC. And by that, you believe that an executive appointment with legislators ultimately voting provides the separation, the balance. I think you used the word equality too. Is that, did I understand you correctly?
That is my preference, Representative. Again, that's getting more into a positional statement. If there's another way where the executive branch of government is equally represented in the selection of judges that also allows legislative appointments, that's a conversation on the commission. That's a conversation I'm willing to have. But right now, what's baked into the Constitution is you all get to create the JMSC, which you have done, and you all have the sole authority. No one else can vote for judges that come out of JMSC but the legislature. And so you have the ultimate up or down vote on who gets to be a judge, and that is awesome power that that should be retained by the legislature. How else do you bring the executive branch up to the same parity? We should not, and we do not get to vote on the final candidates. So that is why I was advocating for, if not all of the members being appointed by the governor, at least a significant majority, and that is preferable to just one or two seats at the table to check a box. I think the executive needs to be an equal partner. That is what I'm advocating on the interest side.
Right. So let me say something up front, and I promise you to circle back and end with it as well. You know, as we've had these conversations about judicial reform, I've hitched my wagon, our caboose, to that train to specifically talk about diversity on our bench, that it be a reflection of our demographics. But really, it's a conversation that, I mean, just quite frankly, if we're not intentional about it, not only is it a weakness, I think it is a problem that will create great lack of trust or distrust in our community. Because one of the things that is at the heart of really our conversation is perception, right? And so when we talk about perception, when we talk about trust, when we talk about optics, even though they're not necessarily real and they are perceived, and even though we've heard the statement, your perception is your reality, I do think we have conversations and dialogue about it, even in our agencies, even yours. When we talk about the diversity in your upper ranks and all the agencies, not to single you out, I think that that is something of great interest to me. And I think when we talk about reform, or a word that I'd rather use, improvements, because I think sometimes reform suggests that there is widespread, in my opinion, either negligence or widespread ethics or illegal issues. And I don't think reform is necessarily the correct word, but I digress from that. Let me get to getting off of diversity, talking about the issue I have with where we are now. The issue I have with where we are now, again, you've self-described it as anecdotal, right? That it's not empirical, it's not stats, and it's not data. Former football player, I love the football analogy, but there is a stat for DBs who don't get thrown at. There is a stat that talks about how many times the receiver was targeted because of who was covering them. But that's here nor there. My point is that when you talk about a CEO and a conversation and what he thought he overheard, and it's secondary and tertiary and down the line of not being primary information, and why that I think troubles me most is in a profession as a prosecutor where you find evidence and you make a case, we're having a case being made against legislators that is not factual, it's hearsay, it's anecdotal, it's, and taking whoever this, imaginary CEO may be, and whatever the conversation that could have had, it doesn't speak to specifics. And when we're talking about, and I don't want to use the word overhauling, but when we're talking about fixing a system, I think the threshold should be higher than that. And so then when we talk about this perceived or potential influence that is being placed on a judge, in balance, I don't see, and maybe it has happened, complaints. I don't see anything being levied against. I don't see the argument being made that it's the judge ultimately who has to make the decision. And so if you believe the decision was biased or partial or was not fair, then wouldn't we direct our concerns toward that judge?
So, real quick, Representative Thigpen, I have tried to stray away from going into a long, and I gave you the CEO example as one example to illustrate how a perception in a civil court with a large company that employs a lot of people and invests a lot of money in South Carolina could have larger ramifications for the state. And it is anecdotal, and I acknowledged at the beginning of my remarks that a lot of the things that we observe, you can't write down in a statistic or a data point. I could give you a lot more examples, and the reason I'm not is that there's a lot of men and women who are going to testify to you today with the remaining time who are going, I don't want to take that from them, but what I can summarize and say is this. I can give you story after story after story where people observed direct influence, where a judge had to say, I have to continue the case because of who is on the other side, even though the case is many years old, or that legislators that are practicing law are acting a certain way in court that if any of us did, we would be held in contempt. And I'm having a lot of, and these, I could go down in the, not just anecdotes, but I can give you story after story after story, and I don't want to do that.
Well,
and by the way, and let me say this, it is a small minority of people that do this, but it is very frustrating for a very large community of people who are trying to keep all of us safe. And so what we're saying is that I don't think the prescription for addressing all of the bad conduct that happens in a court is going to be handled by the commission. That's not what I'm saying. But what I'm saying is that by giving the executive branch appointments on the commission, you're sending a signal that we are co-equal partners in the governance of South Carolina. Right now, we don't feel co-equal.
Let me chime in and say, I should have started here, so let me bag up a little bit. I do believe that we're seeking the same goal. And that is advancement improvements to our judicial system. How we're going about it and what I would say is being used as the catalyst to do it, I'm not quite sure if that meets the standard in my humble opinion. And again, I reserve it as my humble opinion. And when I say that, you know, when we talk about, again, who does hold someone in contempt or makes whatever it is, it's the judge. It's not the legislator, right? And so when we talk about even the influence with whether it's a legislator on JMSC, whether it's a legislator in the body period, I would argue we don't know where the influence came from. You can't factually know where the influence came from, if even influence exists. It could be that they were law partners. Could be that they went to USC together. Could be that they're from the same hometown. Could be that they babysitted them when they grew up. It could be a number of things that could create these type of tensions, and I don't know if these tensions can be avoided. And to suggest that the influence solely becomes from one thing, I think it's moved beyond being objective, and I think that we need to rein it back into so. And when we talk about this in particular to, you know, perceived or real, I mean, the reality is, and I think that's what we have to stick with, is that these tensions do exist. And I'm not sure, with even the suggestions that you've laid out, if it solves the very narratives and the anecdotal instances that you suggested. So say that the executive branch gets an appointment to Judicial Selection Commission. There's nothing to prevent that same court case scenario that you suggested from happening again. It's just as likely to happen after believing you get appointments from the executive committee as it did before. So to conflate the two and say that this is a direct cause or this is a direct impact to that, I don't know if it's fair. I definitely don't believe it's objective, and that is my concern. And, you know, let me say this. I believe in separation of powers. I am for checks and balances. I have no issue with executive appointment on the JMSC. What it comes back to me about, though, is we know constitutionally this responsibility was given to the legislator. And so with that, even though in statute we can deal with Article 5, Section 21 and how we make it up, I still think that ultimately the legislative body has been prescribed or designated as that branch that has the final say. So I believe in input from stakeholders. I believe in people being at the table. I don't believe you're outside at the glass, face pressed up against it. If you are, it's because you choose to be out there. I think there's an opportunity for input. I think that input can be increased. Did you know? I struggle with the attacks and the narrative that is being, I believe, presented, because I believe it's one-sided. And when I feel as though personally something is being described with exaggeration or hyperbole or excessiveness, I'm not saying that a problem does not exist. But if you have something that is a small percentage of what overall is a judicial system, I don't believe that it calls for the type of drastic measures that I believe have been offered in some of the instances. I mean, I think to remove all lawyer legislators in theory sounds great, but in practice, I think it's improbable, and I think it doesn't make as much sense. And so to suggest that, now I'm even open to the ideal of limiting the lawyer legislators or even having term limits. I'm okay with that because I think that provides balance. But when the conversation moves from being balanced, I believe that it really sets us on a train wreck schedule to create more problems than are already there. Because in my opinion, and this is my final question to you, when we talk about the problems that we have from a percentage standpoint, do you believe it is a majority? Do you believe it is something that happens like over 50% of the time? Or do you believe these perceived or probable instances that they are the exception and not the rule? Or do you believe that this is common practice in the judicial system of South Carolina, that there is undue influence being exerted? We talked about the high-profile cases, which we believe is a great example, and you referenced the smaller cases that are not public. In the smaller cases and the spaces and the places throughout South Carolina, if you show up in a courtroom, do you believe that the norm is there will be undue influence exerted, or do you believe the norm is individuals will get a fair case? I, in asking that question, answer it myself and saying I don't think there are enough lawyer legislators practicing for it to be the majority of the cases that individuals come into. So I don't want to, and this is me, I don't want to take something that is isolated or, at the worst case, a small percentage of what happens, and to quote Judge Kittredge on last week, let us legislate, let us improve, let us reform based off of what the norm is and not extreme exceptions, because you yourself have said here today that most of the lawyer legislators do not account for
That I have
small
experience with.
instances. Yes, go.
That I have experience with.
Right.
I'll let other people speak for themselves. I think there was a question in there. Was it about the percentage? I'm not trying to be cute. You asked a question. I want to answer it.
I can restate it if you like,
No. I will say this.
with the
Representative-
same length and detail.
I will say this. I believe the vast majority of the anecdotal stories that we could tell you probably come from a very small minority of practicing attorneys to serve in the General Assembly. The one thing that I didn't want to do is when you come in here, and by the way, a lot of the anecdotes that I've given y'all, I have sanitized to the point to where they really lose their impact, and I've done that to protect identities. But what I can, when you're answering me back a minute ago, you were like, you think it's just kind of, it could have been for other reasons. No, the reasons were clearly stated by the people in the storyline, why the influence is being exerted. And so, and I could give you dozens upon dozens upon dozens of stories, but the last thing I don't want to do is y'all ask for data, and then when we present it to you in anecdotal form, it comes off as an attack. The last thing I want to do is attack anybody on this committee or in this body, the whole General Assembly. I think the vast majority of people in the legislature are honorable people, especially those who practice law. But I'm gonna close with this. Do we believe, this is a rhetorical question, do we believe that all three branches of government should be equal? If that's a rhetorical question, you don't answer me, I'm answering you. I'm gonna answer that, yes. Should we be equal in all respects? Yes. Should we be equal in who serves in the third branch of government? And the answer to that question is yes, for its own sake. Forget the anecdotal, forget the statistical. Should the executive branch have parity of power in the selection of judges so that the people have a direct say who's on the commission? And that is what I'm here today to argue for. And I appreciate the time you've given me.
Well, let me say this. I don't think we're being attacked by the presentation that you have given today, right? And to offer anecdotal stories as, rationale, I don't think is an attack. What I'm saying, hear me clearly, is that I don't think that meets the standard, right? Because even in the story that you told and people say that they said, that they overheard, that this did that, to me, that doesn't meet the standard. And thank you for sanitizing it, that protects whomever or presents whatever. What I'm saying is when we talk about this process and we talk about JMSC and the work that it does, I just think it needs to be a more practical and pragmatic approach to who gets appointed, why they get appointed, what point it is. I think to go into that, to me, is almost kind of like a red herring that's dragged across the trail of who's trying to investigate or figure out what's going on. Again, I'll say it in closing, I have nothing against, as a matter of fact, I would be a proponent for executive input and having an opportunity to appoint to that commission. But I think, and this is just me, and trying to be very objective about it, because I don't think it has to be personal. I think it's beyond this point in time. This system has been here for a while. It outdates all of us here. I do think it needs to be incremental. To quote Judge Kittredge, I do think we need to make incremental changes, review, see how effective they are, then come back to the table again. When we talk about improvement and making adjustments to our system, I think it's a never-ending task. I just, again, am troubled with that piece of it. And to me, that is the part that I think isn't fair to the conversation, and I don't know if it's productive as well. Thank you.
Ms. Wetmore is recognized.
Thank you, Mr. Chairman. Thank you for being here. We appreciate you, and I appreciate your perspective. Like everyone else, I think we're all here for the same goal. The question is how we get there. So, I tend to agree with you that we could look at different makeups of JMSC, look at term limits, all of these things I think could get us to a better perception. I spent many years practicing law, and on the whole, I think that the judiciary gets it right. But I think to the extent that we are here to solve a problem of public perception, I think making some changes could be a really productive way to do that. What I'm trying to, I guess, sort of tease out or get a better understanding of is who that should be, right? And I think your suggestion that it be the executive branch, I don't know that solves the problem, in my opinion. When I read, Justice Kittredge, when he came last week, provided us with an article about the history of judicial elections in South Carolina, written by Professor Wilcox at the USC Law School, and read it with great interest. And all throughout our history of constitutional jurisprudence, we have always vested the power of judicial elections with the legislative branch. I think, probably started, according to this article, with a reaction to the crown, to England. We had settlers here that were very resistant to the idea of the king appointing the justice. So, it talks about how in all the constitutions, all the language in the 1700s, it was always the General Assembly. And then we get into the 1800s, and we did a major reform, and the debate was between popular election and the legislature, and it remained with the legislature as a compromise. But at no point do I see a discussion or a consideration of that moving to the executive branch. And so I'm wondering, constitutionally speaking, where that idea comes from. Where I don't see support for it anywhere in Article 5. Where is this idea of an executive appointment suggested either by our framers or in anything that we have in front of us?
I think you can extrapolate from the founding of our federal government, our federal constitution, and I'm not advocating for the federal system of electing judges, okay? Don't read into that. But, and Justice Kittredge, who I listened to last week in the car while he was testifying before this body, and I agree with nearly everything he said. But one of the things he said, and I'm paraphrasing him, I don't want to misquote him, but he alluded that the executive should be a partner in this process. And I think it goes back to the idea in Federalist 51, I think it was James Madison, and I'm paraphrasing him, that there should be tensions. Ambition should check ambition. And you have three silos of power. You've got the executive, legislative, judicial, and they should all three have checks on each other. That was a constitutional precept in the founding of our federal nation. And we borrowed a lot of those ideas in our state government. We are required under the U.S. Constitution to have a Republican form of government. It doesn't require the same system as the federal model, but that it be Republican. But one of the ideas, Republican in the sense that republic, the point that I'm making is that we can borrow from the federal system that the ambitions of the legislature and executive should be equally checked by the executive branch, just the way that the ambitions of the legislature and judicial should check the executive branch of government. We should all three have checks on each other. I think when the tension is equal, and there should be tension between us. Right now there's tension. We're having y'all are asking great questions. You're pushing back on me. That's good. That's good tension. But in the application of powers of government, there's not equal tension with the executive branch. And I feel like we're better served when the executive branch is an equal partner. And by the way, you were right, Representative, and the others who spoke were right. You guys have been given the power under the state constitution to elect judges. No one disputes that. No one wants to take that or advocate for that to be taken away. What we're advocating for is the Constitution is silent as to who sits in the vehicle, the JMSC, that participates in that process. And it's It's silent, and I'm not saying I presume, but I would assume it's silent because there are some empty chairs there in that vehicle for the executive branch to sit in. And in order to have parity of power in this system, I think the executive needs to have a significant number of those seats. If you want to push back and say it shouldn't be all, the legislature wants to have some appointments, that's a position, the orange, remember the orange? My interest is that the executive branch have an equal say in who sits on the bench, because who sits on the bench then gets to turn and check us back every single day. And my office gets told we're wrong, the solicitor's office get rulings against them. We welcome that, we want that, we think that's good government.
So we agree that it's implied, but not anywhere
Yes, ma'am.
stated. Okay. So right now, we have put in place, we did the big reform in the 70s. We've put in place a number of ethical guidelines, and I have some other questions for Solicitor Brackett about this, but we've put in place a number of guidelines already to ensure, sitting members of the General Assembly cannot run. So if we were to give all or most of the seats to the governor's office, would members of his staff be prohibited from running?
That's for this body to have that conversation when you pass a law.
Would his donors be prohibited from running?
Again, those are all policy prescriptions that this body, you guys can put the guardrails in on the executive branch in statute that he will then have to sign. So those are all good questions that need to be addressed, and there needs to be a lot of transparency. There needs to be a lot of restrictions. I mean, term limits. There's a lot of things that we can put in there, that the qualifications for the members, who they are, how long they serve, what they can and can't do politically. All of those are things are fair we would support that.
All right. My last question is sort of asking for your help.
Yes, ma'am.
As we know, South Carolina is traditionally Republican state. Consistently in statewide elections, we see about 55% Republican, about 45% Democrat in statewide elections. Help me explain to constituents, especially Democratic constituents who elect me, why they would have a voice. You talk so much about the accountability. You talk so much about how the governor's accountable to everyone. I think there is a perception, again, maybe it's a problem of perception, but that many of these elections are decided in the primary. Help me explain to my constituents, particularly those who might not vote in Republican primaries, 45% of South Carolinians, in fact, why they would have a voice with the in this situation.
Well, my thinking on this is not seen through the party lens, and I know that you have to look at it through the blue versus the red lens, and I understand we all have to look at it that way. I don't want a Republican or Democrat judiciary. I don't want a Republican or Democrat law enforcement. I don't want a Republican or Democrat criminal justice system. I want a criminal justice where a victim who has had their life destroyed by some unspeakable crime committed against them isn't re-victimized by the very system designed to protect them. And like George Washington, I wish parties didn't exist. Factions have evolved. And I don't want to design a system of government that's influenced by a party faction. I want to design a system of government where there's a lot of sunlight, so that a Democrat who's governor or a Republican who's governor is afraid to do something that looks partisan because it looks bad. I'm trusting that people, and all of you up here have a political affiliation, and all of you up here have a philosophical viewpoint. But all of you up here don't ever want anyone to say you're not for good government because of your politics. And I believe that the best antiseptic for that is sunlight. Having an open discussion like this, giving the governor the appointments, and you all have the ability to put guardrails on there. And if the governor is putting their appointments on there that aren't representative of the state or aren't representative of the rights of victims or law enforcement who are defending those victims, then that governor can be held accountable. And again, I don't want to go into the partisan lane because I don't think this is a partisan issue. And I've talked to many Republicans and Democrats in this body, and I have seen skepticism from both sides of the aisle, and I have seen total support from both sides of the aisle. And I think whatever you design in your statutory framework for giving the governor that ability to appoint, you can address those political concerns if you want in statute. That would be the only prescription I could think of. But at the end of the day, it's really, for me, it's about how do the victims perceive the criminal justice system? How do the business community see this as a fair state, a good state to do business in? And do the victims feel like they're getting justice? And at the end of the day, that's ultimately what my goal is.
Todd is recognized.
Thank you, Mr. Chairman. General, thank you for being here. Thank you for spending so much time and thoughtfully going over all of the questions and comments that you've been fielding and for your testimony. As you know, I'm not a lawyer, so I might not be as skilled at the dance that I see going on thus far. So I'm probably going to come at you a little more straightforward because here's my concern. I appreciated the analogy, the orange story that you told. The difference that I see between that and this is there was at least an acknowledgement that there was a problem between the two parties in your story. They both wanted the orange. I'm not sure that we have agreement yet, based off of what I have heard, that there is a problem. And if we don't get to that point, I don't know how much thoughtful consideration we can give to a solution. So I'm going to need you to, and whoever comes up afterwards, to unequivocally say, is there a problem? So that we can at least get that out of the way and not dance around that particular issue, so that hopefully we can go to work on trying to find the solutions to either a fix, reform, whatever the terminologies different folks want to use. Now, I get it. I feel it, as I'm sure everyone else in this room feels. There are people that I think are taking this personally. And I get that. As I said, I am not a lawyer legislator, so I cannot understand what my colleagues that are feel like when we have these types of discussions. And I don't want them to feel that way, because I agree with the comments that I have heard that the vast, vast majority of folks currently serving and have served in the past, and I think we've got to talk about that as well. I think the ones that are sitting in the seats now are the ones that are feeling attacked when I would submit that this problem has been going on for some time. This is because I do believe that there's a problem. I don't believe that this is anything new. So this isn't about the ones that are currently on JMSC right now.
Of course.
This is not about any member or colleague of mine that is serving that is a lawyer legislator. And I want to get that out of the way first and foremost as we move forward. To me, it's about, number one, is there a problem? Number two, is there a potential for a problem that currently exists that we need to address? And I believe that the answer to that is certainly yes. And I need not only, and again, so when I ask these questions, they are going to be straightforward. And I'm not asking them just of you, General. I'm asking them of whoever comes up here and testifies as we move forward also. But I really need to get to that. And so, again, in the vein of recently, currently, historically, and in the past, do you believe that undue influence is put on judges by members currently or in the past of JMSC or members of the General Assembly, both the House and the Senate, that may be serving as lawyer legislators?
Yes.
Do you believe that some judges currently or in the past are concerned about retribution by members of the General Assembly that may be lawyer legislators or serve or have served on Judicial Merit Screening Committee?
Yes.
Do you believe that there have been rulings that have been made historically? And this is very pointed, I acknowledge it. Do you believe that there have been rulings or decisions that have been made that would have not otherwise been made except for the fact that a member of JMSC or a member serving in the General Assembly that was also a lawyer on the case was before the judge?
Yes.
Thank you, and I hope that I can get some of those straightforward answers from other folks. Just for any other context, I get it.
I do want to say one thing. I do believe also the inverse is true. I believe that attorneys in the House who serve in the House or Senate have walked into court and got a favorable ruling, and people walked out and said the judge only gave them that ruling because of they're in the House or the Senate. And I don't think that's true either. I think this is as much about protecting those who, there are judges who have ruled in favor of lawyer legislators, and that was the right ruling to make. And there are lawyer legislators who've won cases because they argued the law better and had better facts, and that's true. So it cuts both ways. But I have seen it cut against us, and I have seen the influence, and I've had hundreds of prosecutors and victims see the influence directly with their own eyes. At the same time, this is much about protecting the integrity of the judges. I believe the vast majority of judges, and I think in some ways, I've had judges intimate to me that they hate it when a lawyer legislator walks in and that they're afraid to rule in their favor. Not that they don't, but they're afraid of what people will say. They think about that. And it's not fair to the lawyer legislator who may have a good case. So anyway, I do want to be fair to all parties, the judges, the lawyer legislator, the victim, the prosecutor, and the law enforcement official. It cuts all ways. But yes, I have seen it cut against us because of all the reasons you just said.
And it's not just about y'all. I mean,
No.
that's what I'm saying. I hate that it seems to be, prosecution versus defense or whatever terminology you want to use. Because I'll say this, I've had lawyer legislators that I have served with, maybe not now, but in the past, that have agreed that there exists a problem and it needs to be addressed. Now, guess what? Don't want to come forward. There is a loyalty situation. It exists. I get it. We're human, okay? A lot of folks don't want to step out against those who are in the profession with them for whatever reason. But it has happened. And there are members that have served or are serving that are a member of the bar that believe that changes need to be made, whether they are on legislation or they are not. Here's what I want to get at. I want to go back. It's totally different scenario, but it continues to pop into my brain. I agree with Representative Caskey. Could not agree with him more. I am just as concerned about, you name the law firm in the state of South Carolina, I am just as concerned about one of their lawyers serving on JMSC as I am a member of the General Assembly that's a lawyer legislator serving on JMSC. I think that he is absolutely right that the allowance of undue influence would exist regardless because they have something to gain. There is an opportunity to benefit by that person sitting on that clearly very important panel of screening. So, here's something that continues to come up. It hasn't necessarily been said, but I have picked up on it. Only lawyers can serve on JMSC because they are somehow more equipped to make a determination on the qualifications of these candidates than anyone else. And I have, to this point, accepted that. But as I've sat here and listened to the line of questioning, if that was the case, I, as a member of the General Assembly who is not a lawyer, perhaps shouldn't be able to cast a vote for these judges. So I have learned so much about the process over the course of the last 2 weeks. The Citizens Advisory Committees, all of these folks that do so much work on the front end and through the process of the JMSC screening qualification process, do you believe that only lawyers are able to serve and then make those decisions on qualifications for candidates for judge?
I do not believe that it should be left only to lawyers who serve in the legislature to do that. However, every major governing professional board, medical board, dental board, is going to have members from the profession serving on it. I certainly don't want to see a system where the lawyer is cut off of it. But I don't think you should be discriminated because you don't have a law degree, that you don't have something valid to offer. We have people who've spent their whole lives committed to victims, right? Serving victims of crimes. I think they should have a voice.
But I'm correct, and lots of lawyers are participating in the screening process, just not the vote. And that's what we're getting down to. Who's coming out of the JMSC process and who's not? And who's coming out with a certain classification attached to their candidacy that others are not? And I'm simply asking, do you need to be a lawyer to be able to make that determination after, or can someone?
On qualification.
Yeah.
I think the opinion of an educated person, regardless of whether they have a law degree, if you give someone clear metrics, if it's in the law, that this is what you have to have in order to be an effective attorney, then a non-lawyer can certainly read those metrics and say, yes, you are qualified. And then that person gets a chance to go sell themselves to the General Assembly.
And they certainly can do that with all of the work that is going on the front end throughout that process, correct?
Absolutely.
And so then, if that's the case, if we have a JMSC where the members who are casting the votes and making those determinations have no benefit that they are able to gain in that process, they have no benefit. They're not going to be appearing before ultimately who the victor becomes, because they're not lawyers, right? Would that not then obviously send a very clear message to the public that we are taking this serious and that we are trying to remove not only the perception or the appearance that someone can game the system for themselves, but we are doing it. Like, it's not a perception. We are clearly saying that here is a system by which the most important step in the process, arguably, and I do believe that is the most important step, who comes out of that screening process with certain designations attached to them, that's the big step. Then I believe that we come up with a solution to what I believe is the current problem.
Representative,
Would you agree?
I see where you're going. I would say this, just like a minute ago I said, I don't want to discriminate against someone because they don't have a law degree. I don't want to discriminate against someone because they do have a law degree. Sure. And so, this is, obviously that would address, but there may be other ways to address that.
Yeah, well.
And so, I would ask this body to not look at someone and say, because you're a lawyer, you shouldn't be able to vote or be able to screen who gets to go to the General Assembly. Because you're not a lawyer, you don't get to. I don't want to discriminate against anyone because of the profession they've chosen. You could have a really good, we've had this conversation with magistrates. We've got magistrates who don't have law degrees, and they're some of the best magistrates, right? So I don't want to say, because you do or don't have a degree, that you should be disqualified from serving on the JMSC. I don't want to nail that position down. I'm here for my interest to get the executive branch at the table. So I know where you're going. I just don't want to go that far.
Thank you.
Yes, sir.
Thank you, Mr. Chairman.
I will observe, I think there's going to be a balance, Mr. Ott, wherever we put it, and term limits may play some point too. Say, for example, if I served, but then I wasn't going to be here when you came back for re-election, then I could go practice. That seems like a small thing, and of course, they've got 4-year terms, but we don't have term limits in the statute. So just another idea. Mr. Bamberg's recognized.
Thank you, Mr. Chair. Attorney General, thank you for being here. I do have a really pointed question to ask you, and I'm going to ask everybody who comes to the podium the same thing. What judges in our state that are on the bench do not deserve to be on the bench?
That is a question I'm not going to answer.
And I anticipated that. Okay?
Because let me qualify it. To be able to get the stories, to be able to tell the anecdotes or the stories of people who heard or saw things in real time, and to talk to prosecutors around the state, the one thing that was put on me is, please don't identify who I am. Please don't identify who the judge is, because we all have to appear in front of him. Please. And so it's difficult to tell these stories in a R-rated fashion, because the last thing you want to do is invite retribution or perceived retribution on people who trusted you with their stories. So that's why I wasn't trying to be antagonistic, Representative. I just trying to be protective of the people, and I know you understand that, so thank you.
I do understand that point. But I will, and again, I'm going to ask everybody who comes up here today the same question, okay? And I've already seen in some of the information submitted that it's not going to get answered. The judicial system in our state appears to be under attack, okay? And the difficulty that I am having, and myself, everybody up here, I think, is very committed to trying to improve the process, right? anything created by man is subject to being improved. It's not perfect. I understand that. But we see these stories about individual criminal cases, okay? So the Price case and this and that. But I have not heard a single name of a judge. It's JMSC has these problems. Lawyer legislators don't need to be on JMSC. We need to do this. Maybe we need prosecutors. Maybe we need members of the bar. What judges are the problem, right? And I do understand this idea of, well, worrying about retribution, et cetera. But if the conduct of the judges is so bad, such that the Senate, the House, the Post and Courier, all these news stations, we've got letters coming from solicitors. If the conduct is so bad from any individual judge, there's something that could be done about it, right? How do you make sure maybe they come up for screening and don't get screened out? Well, somebody's got to say something. So if we're here talking about altering the entire way our state selects judges, which is a very big deal, it has not been done that many times historically. If it rises to that level, my problem is, why will no one identify somebody, right? We tell law enforcement sitting out there, myself included, as a House member back home in a small community, what do I tell my community? If you see somebody get murdered, don't play the no snitch game, say something. Go talk to law enforcement. I tell people and SLED agents that all the time back home in Bamberg, and I tell the community, if you see something going on, you need to say something, report it to the police. I'm not a cop, right? But all I hear is a bunch of, respectfully, right, and again, this is not directed to you, the process we're going through, a lot of information criticizing JMSC, and I'm not knocking anybody for how they feel about it, okay, or what they think about it, but the criticism of JMSC, the complaints about lawyer legislators getting certain things in court or whatever the case may be, somebody's got to answer the question of who the problem judges are so that can be looked at and addressed as a part of the process.
May I?
Yeah, of course.
Representative Bamberg, sometimes the judges are the victims. And you were presuming that it was always the prosecutor who didn't want their name mentioned because the judge was going to have retribution against them, but it's the judge who fears retribution and has been told by other judges, you will lose your job if you don't do X. And so it's difficult to appear in front of these men and women who trust us to tell us these stories and these viewpoints. This is about as much about protecting those on the bench as it is about protecting men and women in front of the bench. And it's also about protecting the lawyer legislators who aren't doing this, who aren't abusing the system. You're getting a bad rap. So we're all victims.
What?
And so it's hard to out somebody when you can cost several people their jobs.
What judge it has been threatened, or what judge, who, right? And it's there has to be a person attached to it, right? Everyone involved in the process has an interest. I think it would be very disingenuous to represent to the public as though everybody who is stepping up and asking for whatever their ask is as far as tweaks to the process does not have a vested interest in some aspect of the process, okay? And I'm not saying that's a bad thing, okay? But right now, it's a bunch of groups interested in what they want with phantom problems, right? Everyone, it's hey, I have a problem. Well, what is the problem? Well, such and such and such and such. Okay, well, where's the proof? You know, that is the problem that I'm having, is that some of the stuff being said is very bad stuff. These are not small allegations to levy against either the judicial branch of government. You know, I really wonder if some of the public concern stems from one-sided representations about what the problems are, but no one can identify, no one is, other than individual legislators that people have a problem with. No one can identify any other parties in the judicial branch who is afraid. Who? Are you aware of who is afraid? What judges are you aware of that are afraid?
I am
that.
aware that people don't come forward because they don't want to lose their job as a judge, or they don't want sometimes it's the judge who's the victim, sometimes it's the prosecutor who sees the judge and the lawyer legislator doing something that they perceive as inappropriate. Sometimes it's other parties, but the point is that if you come out and you identify, again, all of these examples I have here are I was promised that I would not identify the jurisdiction, the judge, or the individuals involved, but that I would sanitize it so that it couldn't be termed, because they don't want retribution. Now,
And
some
I
of my
want you to
colleagues
keep
may,
your- I
some of
want
my
you to keep your
colleagues might be able to
promise.
speak for themselves, and they might be able to give you direct, and I presume they will. But, we've heard jail calls where inmates in jail say, yeah, my lawyer says they got influence over the judge so they can get this thing resolved. I mean, we hear these things, and whether the judge did anything wrong I'm not saying that. That's what people believe. And we're trying to address that perception.
So we're supposed to change the entire judicial system in this state because of a couple of jail phone calls of someone saying, my lawyer said, or someone said. That is the problem that
That's not what we're
have.
asking, Representative.
Let me ask this. In this state, there are 16 prosecutorial circuits, right? 16, and they're elected by the public in their circuit, right? Are prosecutors a part of the judicial system in our state?
Yes.
All right. Who controls prosecutorial dockets in our state?
The courts.
The courts do? Who calls the cases?
The prosecutor.
The prosecutor.
Working with the court.
Okay. Do you remember a few years back, and this matter was before the Criminal Law Subcommittee, a few years back, there was legislation regarding, and I'll tell you why I ask you this. There was legislation regarding taking that power from prosecutors, the ability to effectively control the criminal docket in this state, and putting it with the courts, like it is in common pleas, right? In common pleas, the courts control the docket, right? Do you remember any discussions about that, or what the prosecutor's stances were with regards to the judges possibly taking over their dockets in criminal court?
Yes.
All right, and they were against that, were
Yes.
they not? They
Yes.
were. As a part of this process of judicial review, basically, all right, what changes can we make? Obviously, we're looking at JMSC. Obviously, there's discussion about magistrate level, right? Are the prosecutors in our state okay with a part of that review also entailing whether or not their ability to control the criminal dockets go to the court? I mean, if we're going to fix JMSC, that should dead the concerns about the fairness of judges, right? So why can't you can't speak for them. I'm going to ask them the same question. From the Attorney General's standpoint, would the Attorney General's office have any problem with the courts being the ones that call criminal cases like they do in the civil context?
The courts have already spoken on this issue, and we don't agree with it, but we're abiding by it. And something you said a minute ago, Representative, I just want to make sure you're abundantly clear. We're not trying to overhaul the judicial system. We're simply asking for a seat at the table to the selection of judges. That's not overhauling the judicial system. Giving the executive branch of government a seat at the table, an equal seat, an equal player, a partner with all of you as it relates to selecting judges. You get to vote on the judges, but let us have an equal seat at the selection and qualification process. Is it going to cure everything? Of course not. But it certainly gives us a seat at the table, which is what we want.
I understand. And I'm not knocking anybody, right? This is part of the process, right? Everybody has input. But I need to know, the Attorney General's office is the chief prosecutorial office for the state, right? Just like the U.S. Attorney's office is the chief for the feds in the state. Would you see a problem with the courts taking over? And I'm sure at some point someone's going to speak to the backlog of pending and open criminal cases in the state of South, and it is a ton of them, right? But there are a lot of crimes that committed, okay? So it is what it is. But should the courts take that control? How does it work right now, right? A solicitor goes and they say, all right, here are our open cases, and we want to call this one for trial. Or, hey, we want to do this on this one, right? And the judges accommodate the prosecutors, right? That's generally what happens. The judges do accommodate the prosecutors in what they choose to do, correct? So are the prosecutors in our state, as a part of this process, okay if at the end of the process and recommendations are made, one of the recommendations is that the prosecutors no longer get to unilaterally control the criminal dockets in this state?
They don't unilaterally control them now.
All right, and I get you saying
I mean, the
that,
court's
but-
already ruled on this. I'm not trying to be
No, no.
difficult. And Representative, if I can, and look, I am happy to stand up here as long as this body wants. You have oversight over me, and you're asking great questions, and I will be here as long as you want me to be, but I also feel like there's a lot of people sitting behind me who are going to testify probably as long, and y'all are doing a hard break at 2:30. I'll come back. I'll come to your office. I don't want to monopolize the entire hearing. I will monopolize if you keep me up here, but I also don't want to take away because they have a lot of thoughts on this too. And I'm here not to represent them because you're going to get a bite at the apple with these solicitors and the sheriffs and the chief. So anyway, I only say that to say I'll come back to another meeting and I'll stand up here and take fire on the docket management, and we'll do that if that's what you want. I just don't want to monopolize and take away their time.
I'm trying to give you as much airtime today. You look great.
And
Okay.
you look great too.
But let me ask you this one last thing. And to my committee members, I do apologize. All right, so we've seen a lot of mention of crimes and a lot of talk about victims, okay, and about how this impacts them, et cetera. All right, in our state, would you agree that when the alleged perpetrator is a member of law enforcement and it involves someone's civil rights violations, right? That happens in this state, right? Mm-hmm. Unfortunately, sometimes that
Allegations,
happens. And the prosecutors control that review, right? Yeah. Why is there nothing in anybody's letter about the fact that there are innocent victims that are citizens in the state with constitutional rights? Right? Bryant Hayward in Charleston, 4 years, that young man who was rendered a quadriplegic, for 4 years, he waited on a decision to be made as to whether or not the individual that shot him in the neck would just be indicted or freed for 4 years. Your office actually had to take not only that case from a solicitor's office, but a number of other cases. I would be interested as a part of this process this is for everybody watching. If groups are gonna make presentations, please don't make them so one-sided. Because if you want credibility, there are members, myself and others, that really want to listen to legitimate concerns. Not self-interested concerns about, we don't like decisions that were made. Everybody's a prosecutor. I hadn't seen no judge get indicted. I hadn't seen none of that stuff. Raise legitimate concerns, but I am seeing a bunch of stuff that is so one-sided. If you're gonna talk about victims, talk about all victims, right? Who can these citizens go to? We talk about people not feeling like they have a fair shake if it's a lawyer, legislator in court, or the judges are worried, or the prosecutor feels like something, et cetera. Who do people go to when it's the solicitor's office that's the problem with the judicial process? What citizen should have to wait 4 or 5 years to find out if the government is going to defend them?
Well, and again, I don't want to go down a rabbit hole, so I'm going to not go down a rabbit hole for time's sake. But there's always a side of the story that doesn't get told as to why a prosecutor does or does not do something. Sometimes it's because they can't get certain lawyers into court for years. And I'm sure some up here may testify to that. But if there is a specific case that we have been involved in, and you're saying we took a case that wasn't getting tried, I'm happy, and I have 8,000 cases right now on my docket. I'm happy to sit down with you and/or the solicitor to have a conversation to give you the answer. Because if we owe you an answer, if it's an ongoing case, it may be limited, but if I can give you the answer to your questions on those cases, I will.
And I'll clarify, the delay, I'm not talking about the Attorney General's office.
Okay.
I'm talking about when SLED finishes and the solicitor's office is the one that gets to make the call. Do we indict? Do we not indict? Do we present it to a grand jury? Do we not? And a citizen who's been victimized, unfortunately, right, has to wait so long. This is again, there are a lot of problems. We talk about, because we're looking at the judicial process here, the selecting of judges, how can we improve things? I just think it would be way more credible if when folks submitted information, it wasn't so one-sided and only about the things they don't like, while not actually mentioning any of the other problems that the institution of prosecutorial bodies in this state are contributing to, that fall in line with the same thing they're complaining about other people about. That is all I'm saying. And thank you so much for
Thank you, General.
for all your time.
Thank
Mr. Bamberg, a couple observations. One, I think the Attorney General was referring to Langford, which I think was like 2012. That's when the Supreme Court said the judges do call the cases. So the bill I think you're referring to was mine, where I was trying to get it back for the solicitors to call the cases that, but anyway, so right now there's hybrids in both circuits. But fortunately for all of us, we're going to get to hear from the solicitors now, so you can ask them about all kind of things. Ladies and gentlemen, you heard we had a hard stop at 2:30 in classic legislative time. We're going to make that hard stop 3. I want to be respectful to everyone who's here. General, we want to thank you for your time. You're welcome to remain with us. We're going to take our 10-minute break. And then my intention is to hear from the solicitors. If Professor Fitzpatrick is still available when we get through hearing from the solicitors, we'll take him. Anything after that, starting with Hugh and Chief and the sheriffs, I just want to be respectful of your time. That it looks like that's gonna, you saw this took 2 hours with one witness, so, because I don't want to shut down anybody's ability to ask questions or you guys to provide a good response. So if any of you guys that are later down, I know we got Judge Dash too, any of you, the chiefs, anybody that needs to leave, if you'll just let staff know, our intention's gonna be the week after Thanksgiving. I think what we'll do, we were talking about an afternoon hearing so citizens could get off work and participate. What we'll do, and of course we had defense bar members request to speak. I think we'll shoot to having a full day that day, probably start in the morning, maybe take up where we have our agenda now, and then and fill in with the citizens in that afternoon. So that's the best I can do for you right now, but I didn't want you stuck here and suddenly us stopping and you still sitting in the audience. So feel free, and if something happens, you feel the need to leave, we can certainly put you on the agenda next time. I'm really looking at the folks that I don't know that, I'll be surprised if we're fortunate, we'll get the solicitors and Mr. Fitzpatrick if he's willing to wait with us. But staff, if you'll check with the professor, see